ABC4 at 5, I'm Jennifer Bullock.
I'm Jared Smalley. After 4 years of legal arguments, survivors of a sexual assault at the hands of OSU Dr. Richard Strauss will soon know if they can take their claims to trial. An attorney for Ohio State and an attorney for more than 100 of the plaintiffs today argued before a 3-judge federal panel over whether or not the statute of limitations should block the claims of former students. And so Colleen Marshall joins us now. She's covered this case extensively, spent much of today listening to the legal arguments made here. You would know firsthand. What's the update now?
You know what I find fascinating about this case and these arguments today? No one is denying that the doctor did it, and today they were not arguing that the university knew about it. Everybody knows this is what happened. No one denied that the university officials back then knew about it and tried to cover it up. In fact, both sides are using that in their argument. The attorney for the Strauss survivor says the university knew what was going on under the guise of required physical exams between 1979 and 1998, but covered it up. The attorney for the university says the students should have known back then that they were sexual assault victims, and they should have filed their claims within the 2-year statute of limitations. No cameras in the courtroom, but you're going to hear now from both sides, beginning with Michael Carpenter, the attorney for Ohio State.
If you read the graphic statements that they put in their allegations in this complaint, it is incomprehensible, but more importantly, from the standpoint of the Supreme Court, it is not plausible that these persons were not at least on inquiry notice to determine that their rights were being violated and what they could do about it.
And so OSU is coming to this court hand in hand and saying, please reward us for our mendacity. Please reward us for lying and concealing and obfuscating for 40 years because we were so successful at lying and concealing the abuse and our response and our knowledge that we managed to get past the 2-year statute of limitations. That's the rule they're asking. They are asking this court, their rule encourages universities to cover up abuse.
And the court will now decide whether the statute of limitations should be put aside and the case allowed to proceed to trial, or whether those claims simply came too late. And Jennifer, we should know in a couple of months which way they go.
All right, we know you'll continue to follow it for us. Colleen, thank you.